Hi everybody, and thank you for joining us today for our first construction clinic. My name's Nina. I'm going to take you through a very short housekeeping presentation and a very brief introduction to the Institute if you haven't heard of us before, and then we'll get into today's presentation, which is on the topic of notices. Okay, so you should all see on your screen a control panel. If you have any issues with audio today, I'm conscious that lots of us are working from home these days. So just raise your hand. You should see the icon. Oh, sorry, hang on your screen there. We'll try to do our best to help. You'll also see a chat icon. Which will light up in orange if we send you any messages. That's that one just there. So do just have a quick look at that. We might send you links for more information and bits of information. So keep an eye on that. And the clinic format for today. So this is the first construction clinic. It's kind of evolved off the back of the public webinar series, which we started last October and it just finished in March. Those sessions were really well attended, and given now the situation we find ourselves in with coronavirus and many companies trying to protect staff and have them work from home, we wanted to kind of do our bit to bring the construction community together and help with the sense of self-isolation that we might all be feeling. So it's a weekly 30-minute clinic. We'll have a very brief presentation and then we'll be opening the floor up to questions. We do invite you to send questions in beforehand, so if you've got written questions, to email those in. We'll prepare responses and we'll kick off each session with those before opening the session to everybody live to send their questions in through the question box, which you'll also find in your control panel. We do ask as well if you wouldn't mind trying to keep your questions on topic. We've tried to plan the sessions so that the presenters that we have for you have expertise of different professional backgrounds. So the topics that we deliver and the presenters that we have, we make sure that they'll be really well equipped to answer your questions. Of course, we're aware that other things might pop up, but if you could really try and keep your questions to the topic each week, that would really help us to deliver a successful session for you. The presentation materials and the recording for today are in the handout section on your control panel. You'll also find our membership brochures if you want to learn a bit more about us and how to join our community. And the recording for today will also go out in the follow-up email, which you'll get later this afternoon. Okay, so the ICCP, very brief introduction. If you haven't heard of us before, we are a professional members organisation and we exist to recognise those with skills, qualifications and expertise in the professional management of construction claims. We have three core objectives, and those are to establish international professional standards for the management of claims, to give recognition to those who have gained appropriate knowledge and experience in the management of claims, and also to help and educate those perhaps at the start of their career who would like to gain that experience in the management of claims. So our membership levels, we offer 3 levels of membership: associate, member and fellow. Associate is our entry-level membership, and members joining at that level are encouraged to work their way towards full membership through additional courses and qualifications. We then have member, which is available to those who can demonstrate appropriate qualifications and expertise to be able to prepare, present or manage claims to a suitable professional standard. And then finally we have fellow, which is reserved for those who can demonstrate really significant experience in the profession. And fellows are also encouraged to get involved with the Institute to give back to the more junior members, so be it through our mentoring programme, presenting webinars or submitting articles for our private members area. So very brief introduction to membership there. If you'd like more information or you'd like to have a chat about any of that, you can get in touch with us either through our website or contact us directly, and my email address is there for you. Okay, so on to today's topic of notices. So I'm now going to hand over to Andy Hewitt, who will be our first presenter for the day.
Right, thank you, Nina, and good afternoon, everybody. It's fairly going to be a fairly brief presentation here, but we're going to just have a look at the notice requirements under most form of contracts. We're not going to talk any particular form of contract, FIDIC, NEC, JCT, whatever. This is generic advice. So let me make sure that the screen's going. I think everybody should be able to see the screen now. Whatever type of contract you're working on, whether it be, you know, the FIDIC suite, NEC suite, JCT, ICE, whatever, and in fact, many bespoke forms of contract, will oblige the contractor to give notice if certain things happen. And, you know, there's a couple of examples. An event that may lead to delay or additional payment is likely to occur. And the one that immediately springs to mind is when the contractor needs information from the engineer, architect, consultant, the issue of drawings, the issue of design, nomination of a subcontractor. So if we don't get this by a certain time, we're likely to be delayed and incur additional costs. A notice that an actual delay, generally for something that the employer accepts the risks on, or the incurrence of cost has actually occurred. So, Mr. Engineer, we didn't get the drawings for the whatever, and now we've got our people standing by without any work to do because we still haven't got the drawings. We're therefore being delayed and we're incurring costs. And then finally is notice of intention to make a claim. So, yeah, Mr. Engineer, we still haven't got these drawings. We've had our guys standing around for a week now. We've incurred this cost. We are being delayed, and we believe that the contract entitles us to make a claim. So we're going to be submitting a claim. So these are the basic things. Let's just have a quick poll, though. And let's have a look at what you guys think. So, Nina, if you could launch the poll question, please.
Yeah, okay, so our poll question for today, are you working on projects where submission of notices is condition precedent to entitlement to an award of an extension of time or additional payment? If everybody could just select their answer for us now, please.
Take you some time.
Yeah, we are just getting up to about 85% of people have responded. We'll just give it a couple more seconds, see if we can get a few more, and then we'll launch the results.
I'm just going to have a little bit of a punt, and I'm going to guess at 85%.
Okay, right, let's have a quick look at the results. Okay, so 91% say yes and 9% say no.
Well, that's actually more than I thought, but the answer is still pretty conclusive, isn't it? That if you don't comply with the notice provisions of your contract, the contract says that you can't actually have anything. It's a condition precedent. So let's move on. Hang on, just 1 minute. I seem to have lost my cursor. Or have you handed back the presentation to me, Nina?
Just click onto your screen, Andy. It should bring the screen live again. There you go.
Okay, I put this in big letters, so hopefully people take notice of it. But in my experience as a project manager and a contracts and claims consultant, failure to submit notices is one of the biggest failings of contractors when it comes to claims. If we're employed as consultants to manage the contractors' claims for them, one of the first things that we're going to need to see is the notices that have been submitted. If we're working on behalf of the consultants or the consultants themselves, if notices are a condition precedent, this is going to be the #1 place they will look for a reason to reject your claim. So these are vitally important. But when and why are notices required? But, you know, I get contractors saying, well, the engineer knew about it and it doesn't really matter and it's obvious and all that stuff. But, you know, the contracts don't make them conditions precedent for nothing. So let's just have a look at why they are given such importance. Firstly, to advise the consultant and the employer that an action by either of them is needed or will be needed. Maybe, you know, the engineer or the employer didn't really know that the nomination for the whatever contractor was needed within 1 month. So the notice gives them a timely reminder of it. To advise that an action or inaction by them is likely to lead to delay or additional cost to the project. So, Mr. Employer, you've asked us to put another 2 kilometres to the end of the road that we're building for you. That's going to be asking for extra money for it. Or conversely, going back to the issue of the drawings, the design, or whatever, failure to respond to our submittals, failure to do this. So the contract says it's not enough for the engineer to supposedly know that he needs to do things. Contractors have got to send them a reminder by way of a notice. To advise the parties that an event has occurred which will or may lead to delay or additional cost to the project. Here's a topical one. Force majeure, we've got a coronavirus and it is affecting our project like this, like this, like this. It's going to have a detrimental effect on the project. Sorry, that was my quick presentation. It's time for me to hand over to Paul to finish this off. Thank you. I'll be back for the question time.
Sorry about that. Okay, good afternoon, everybody. Sorry about a little technical hitch there. So, why are notices given and why is there so much importance under construction contracts? In order that the employer or the consultant can take mitigating action, this is normally a reason as to why a notice should be given. And it allows the employer or the employer's agent to, in essence, ascertain whether the contractor should have undertaken any mitigating factors which could save on the claimable costs which the contractor or the subcontractor might be looking to claim for in the future. So the NEC asks for an early warning to be provided, and there's a reason behind that, so that the project manager and the employer can look at what mitigating factors might be undertaken to mitigate the effects of any delays. So the notice is quite important for that. It might enable the employer or the consultant to plan and make provisions for additional time and finance if mitigation is not possible. So that's another reason why notices are given so much importance. So what should be included in a notice? Well, the notifying document should clearly state that it is a notice. Now, when we advise clients, we actually tell them that it should be reference notice in big capital letters. And we had a situation a few years ago where we're representing a subcontractor, and it was under a specific MF1 form. And there was circa 3.8 million sterling riding on the fact whether the notices that had been given were clearly notices under the MF1 form. Fortuitously for our client, they actually won on that basis. However, we had to really demonstrate hard that it was a formal notice that was being given at that time. Reference should be given in the notice to the clauses that require the entitlement to be attached to. But be careful here. Don't be issuing your notices with the incorrect clauses because this might limit your rights to claim in the future. So just be understand your contract, understand what it says about the pertinent notice to be issued, whether it's for time and money or separately looking for time. And describe the event or circumstances in the notice. Do not include the claim in the notice. You're just literally advising of the events or circumstances which you're looking to claim for. And most importantly, you need to reference the date of the event or circumstances that the notice happened. And why this is important is most contracts say that you must issue the notice within a reasonable amount of time, or a specific amount of time if the contract is explicit. And failure to do so, as Andy has already referenced, might well be a condition precedent, and you might then lose your right to claim. So all the requirements for notices: or deliver it or transmit to the place and or by the means stated in the contract. So if it says that it needs to be hand delivered to the registered office of the contractor or the employer, make sure you do that so that it's compliant. We have seen in the past in contracts that emails are not a form of notice, they are struck out. So it's not acceptable to issue notices by email. They have to be formally issued to the project manager or the contract administrator. That might be by letter, it might be hand delivered on site. So really understand what the delivery and transmission process is. Otherwise, again, you might think you've issued your notice, but equally, you might have failed to do so. And if sent by the consultant, then copy the employer and vice versa. And this is important so that the employer, the person that's going to be paying you, understands that they're having to deal with something of a contractual nature. We think this is a good idea that in most, well, in fact, in all cases, we would ask that and suggest that all notices are included in the progress reports that go out on a monthly basis by the contractor or the subcontractor. And this is good housekeeping, really, to keep a track of the notices that have been issued, to be able to deal with the effects of any at-large notices. And it also shows on a contemporaneous basis what information has been issued to the contractor or to the employer contemporaneously, if indeed you need to look back over time. So again, good practice for notices. Do avoid accusatory language and finger pointing. This is not the requirement of a notice. The notice is a matter of fact. You're stating that you've been delayed, disrupted, you've got additional variation, you incur more costs, and it's your notification of your right to claim. Make the point that the submission of a notice is an obligation of the contract. So I would suggest that you need to be saying that if it's pursuant to a specific clause under the contract, state that the contract says you're submitting this notice. Provide the information that the contract requires in the notice. So if it says, state the date of the notice, state where and when the event was first felt, put all those details down. If it's asking for further evidence, be that by further drawings, information, please send that across in your notice so that it's got enough information for the person dealing with the notice to sufficiently say, yes, I accept that as a notice or not, as the case may be. And as I've said, do not include too much information in the notice. The details of entitlement will be included in your subsequent claim, and that will be a follow-up to the notice in due time. And use the language of the contract in the notice. That's obviously very clear and should be done in all cases. And if in doubt, I would always submit a notice so that the contractor or the subcontractor could always go back over time and say, well, there's my notice, there's my contractual entitlement, and I can build my claim around that accordingly. Okay, so that brings me to the end of my quick whistle-stop tour on notices. So some questions open to the panel. We have got some questions that have been issued already. Some of them are a little bit off topic, but I will continue to discuss the questions that I have got, if that's okay with Nina and Andy.
Yep.
Okay.
Yeah.
Super. So got a question here that was emailed to me. It's more to do with the programme, and it was in the context of an international ad hoc arbitration process. And the question goes on to ask, as part of the dispute, where the dispute relates to actual contract completion date, would the contractor's soundest method be to evidence the actual contract completion date, or to produce a retrospective as-built programme based on actual records and not programme updates? And the question further goes on to ask, in my experience, how should programme delay analysis be presented? Should it be presented in Primavera or in a simple Excel format? In answer to the first part of the question, I guess it all stems to what stage the project is at with relation to are we doing a prospective view or a retrospective view. If the contract is completed and if the dispute is underway and the contract has been completed and the practical completion date has expired, then there's a case law in the it's an Ireland case law, Northern Ireland Healthy Buildings case, where the judge went on to say, basically, why should I grope around in the dark when I've got the actual facts in front of me? And what they meant by that is that the judge felt that he had sufficient as-built information that allowed the the contractor to determine what actually happened in terms of the progress delays, and asked for all as-built information to be provided and the programme to be provided. So that was quite clear in that judgment, that the judge was saying, if I've got the information before me and you can carry out a retrospective view, then you should do so and deal with the facts accordingly. If the project is yet to be completed, then I will be suggesting that one might want to go to the Society of Construction Law Delay Protocol, where it references which method of analysis would be appropriate. And indeed, it might even be written within your terms of contract. So again, it depends if the contract is prescribed a method of delay analysis, or whether there's one more favoured by the Society of Construction Law Protocol document edition 2. So that will be my advice to the person that's asked the question over retrospective versus prospective view. And in terms of the determination and presentation of the information, I would always like to see, obviously, the detail in the Primavera or ASTA submission. However, you've got to appreciate that when you're dealing with a tribunal, they do not understand the ins and outs of the Primavera ASTA software. And what we try and do, and I think this is good practice, is we simplify it. And we make a very simple Excel's type document flow chart that basically takes the reader by the hand and leads them through the submission using the evidence of the Primavera and ASTA detail as supporting documentation. So yes, certainly to the detail, but when it comes to explaining it to the layperson, simplify it, keep it simple. That's what I suggest. Thank you.
Right, Andy, would you like to now deal with the questions which you received?
Yeah, sure. Hope I'm back. Thank you, Paul. Right, we've got questions related to COVID-19, surprisingly, and also notices. So let me take them one by one. First one from Simon Rowlands, who seems to get good money out of these webinars and various emails that he sends to me. We're going to have to start charging you consultancy fees, Simon, but nevertheless, it's a very good question, and thank you for submitting it. This is related to the Red Book 99 and the coronavirus. First question, does the contractor have any duty obligation to mitigate delays and costs? And if so, to what extent? Now, FIDIC doesn't give any explicit obligations to the contractor to mitigate. However, in most jurisdictions, it's an implicit requirement that both parties work together proactively for the benefits of each other. So there's an implicit obligation to do what you can to mitigate the circumstances. Now, the SCL protocol goes further than this and actually says that, yeah, mitigation should take place, but not to the extent that the contractor should incur additional costs or mobilize additional resources. Now, here we're talking obviously about recovery of delays. So that deals with number one. Second question, should the engineer instruct the contractor to carry out mitigation measures if the contractor is not doing so? Now, if I was to put my the employer's side of the fence project management hat on, I would be very, very careful about giving the contractor an instruction to do so, because that could be termed as a variation, and the contractor could then come back with me with a claim for the variation. We've got to think very, very carefully about it. Having said that, we're going to, there's another question that allows me to go into that a little bit more. Question 3, in addition to claiming an extension of time under 8.4, should the contractor issue notice of claim under subclause 13.7, adjustments for changes in legislation? Now, I've had this question before, and clause 13 deals with variations. So 13.7 deals with adjustments to changes in legislation that would affect the design or the construction of the work. So, for example, if the building regulations change to require something more expensive before the building can be completed and signed off by the local authority, that would be a change in legislation which would lead to a variation. There's then an argument that does that variation entitle you to an extension of time, but this is not really relevant to coronavirus. Subclause 19.2, should we give a notice of force majeure? Now, the jury's still out under FIDIC on whether the coronavirus actually qualifies as a force majeure event, and my pendulum is swinging both ways. First of all, I thought FIDIC has 5 conditions that has to be satisfied, which it does, but then it goes on to list a list of the type listed, so things like war, volcanoes, and my initial thoughts was it's not of the type listed. But doing a little bit more research, FIDIC are sort of saying in their user's guide that it doesn't have to be of the type listed. So I need to do a bit more research on that, but the pendulum now is swinging the other way. I'm also in the middle of looking at various statements and papers and things put out by lawyers and trying to get a handle on what they think in terms of the legal application of force majeure. But as we said earlier in the presentation, if you think it might qualify as a force majeure event, submit a notice anyway. One thing I didn't mention about the notices is that if you submit a notice, there's nothing wrong with you then going back and saying, look, we've investigated this further. It wasn't as bad as we thought it was. The events that were being delayed weren't on the critical path. We won't be pursuing a claim. So in effect, you can't withdraw the notice, but you're telling the other side that, okay, we've looked at it and it wasn't an effect, we won't be putting a claim in. What a nice contractor. First of all, he's drawn our attention to the fact that there might be a problem. Then he's told us that it's not a problem, forget about it. I think that's proaction, or proactivity, should I say, from the contractor, and the consultant should look at it that way. Last point, at what point should the engineer consider subclause 8.8 suspension of work? Now, okay, we've got a situation with the virus that the projects could be on lockdown, on delay, for whatever reason, depending on how your country's been affected and how the project's been affected. If we consider it's a force majeure event, well, possibly the contractor might be wanting to claim his costs for prolongation. If it's not a force majeure event, possibly the contractor won't be entitled to claim for costs. So I think the engineer and the employer have got to sit down and think about at what point is it better to instruct the contractor to suspend and possibly pay demobilisation and remobilisation costs. We can't have this going on forever. And really what I want to advise everybody is that, you know, I am a claims guy, I'm a contracts guy, but I spent many years being a project manager. And I do think that project manager for both sides of the fence, I do think this is an extraordinary occurrence. It's going to affect everybody. We can't blame or portion blame to any party. So one of the things I want to encourage everybody to do, whichever side of the fence you're on, is to start a meaningful dialogue. Sit down with the contractor, the engineer, the employer, and try to work out what is best for each other and what's best for the project. The type of engineer stroke consultant that is just going to sit down and say, well, we're not going to pay the contractor anything else, and we're not going to accept the claims for force majeure because we don't think it's a force majeure, and just sit there and put on the contractor's shoulders. Well, just think, the contractor could very well go bankrupt unless you help him. Then you've got a project that's half completed that will never get completed. And there's lots and lots of other implications. So please, if you're in a position to start a dialogue with the parties involved in the project, let's do that rather than having to get the contract out, submit claims, go to arbitration, and make a bad situation worse. That did take rather a long time. Simon, I hope that answered your question. Unfortunately, I've got the referee blowing the whistle on the 30 minutes, and I know Paul's got to dash off for another call. So I think that's all we've got time for this week. Thanks for attending. Thank you for your questions, and we hope to see you this time, well, probably not Paul or I, so some other people, this time next week. And please do have a look at the ICCP. We are a small, friendly organisation, and we like to try and help people rather than find excuses to be unhelpful, for want of a better word. So back to Nina, thank you.
Hi, thanks Andy, thanks Paul. Just to wrap up today, the construction clinic is going to be taking place every week. It's going to be Tuesday at 1 o'clock GMT. So if we've had tons of questions in today, which I'm really sorry we haven't had time for. So come back next week. It'll be on a different topic. We'll have Andy and one of our other committee members, Lee Spall, presenting, and we're going to be talking about delay and planning. So get your questions ready, join us next week, yeah, we really look forward to continuing the clinic with everybody. So thanks for attending today, and hopefully we'll see you again next week. Bye-bye.
Bye now.
Bye. Stay well and safe.